Thank you, Ward, and thank you all for joining us today. I'm Kerry Cork, a Senior Staff Attorney at the Public Health Law Center and Tobacco Control Legal Consortium. We're delighted to host today's webinar on global tobacco and trade litigation. The tobacco industry has a long history of using international trade and investment agreements to challenge tobacco control measures, such as plain packaging requirements. This webinar will provide an overview of the latest tobacco, trade, and investment litigation. We have a lot to cover today, so I'm going to keep my opening remarks brief. I just want to start by saying that this webinar is sponsored by the Public Health Law Center's Tobacco Control Legal Consortium, our national network of legal centers and attorneys that support tobacco control policy change at the local, state, and national levels. We do this by providing free legal technical assistance to tobacco control advocates, public health professionals, local and state health departments, coalitions, government and private attorneys, and individuals. For more information about our organization, please visit our website at www.publichealthlawcenter.org. We're delighted to introduce our speaker today, Robert Eckford, who's presenting from the UK. Robert is an Associate Director of the Campaign for Tobacco-Free Kids and its International Legal Consortium. He provides specialized advice on trade and investment law issues. Rob previously worked as a public lawyer in the United Kingdom for 10 years, including periods with the official solicitor and the Department of Health. He led the legal advice to government on standardized packaging of tobacco, along with a number of other tobacco control measures. He's also been involved in litigation brought by the tobacco industry, including the legal challenges to standardized packaging, the ban on product displays, and the challenge to the European Union's Tobacco Products Directive. Before we start today's presentation, I want to remind you again that we'll have a facilitated Q&A session at the end. Please use the Q&A box at any time during this webinar to submit your questions. And as Ward mentioned, we do have a very short webinar survey that we hope you'll complete. So with that, I'll turn things over now to Rob.
Hi, everybody. So, as indicated, this is a talk about international trade and investment. So, I'm just looking for my notes, which I don't. Hold on just 1 second. Okay, no, we do have them. I'll sit back. So, the first question I think that we can ask ourselves is why do we need to know? I'm a public health lawyer, you're public health lawyers or public health officials. Why on earth should you care about trade and investment law? It's a fairly niche area of law, even for international lawyers. Well, perhaps to point out the obvious, and probably most of you will know this already, tobacco and tobacco products are traded internationally. And the tobacco companies that have the vast majority of the global market are multinational corporations which act as foreign investors in most countries, and so are given protections under investment treaties. Now, it's important to know that in almost all trade and investment agreements, with 1 or 2 exceptions, tobacco and tobacco products are given no special status. It's just another commodity, it's just another traded product. And so no account is taken of the fact that it is the most harmful consumer product on the planet. But we also have to know that there is space and flexibility within all these international agreements for governments to regulate in the public interest. But that space needs to be protected and defended at times against what can be overmighty corporate interests. So before I get into the specific cases, I want to run over some basics. And the first one of those basics is just to understand the difference between trade agreements and investment agreements, because they are different things and they often get lumped together and talked about in the same sentence. So trade agreements to start off with. The most common, the most widely committed to, most well-known free trade agreement is the World Trade Organization agreements. But free trade agreements generally deal with the very similar issues. And these are the terms of trade as between countries. These agreements only confer rights upon states as against other states. And they govern the tariffs, they govern things like the tariffs on imports, trade barriers, subsidies, environmental taxes, and protection of intellectual property. The World Trade Organization agreements cover all these matters, and regional FTAs have similar provisions. The most sophisticated free trade agreement is the EU treaties. If a free trade agreement is breached, then other states can initiate dispute settlement procedures. But disputes are always as between two or more states. Private companies cannot bring trade disputes, although, as we will see later on, they often seek to sponsor or encourage states to bring disputes essentially on their behalf. The remedies if a breach of a trade agreement is found, the remedy is for the other countries or country to instigate legitimate trade sanctions. Investment agreements are different. These are about direct foreign investment rather than trade per se. They confer rights mainly on individuals and companies that can be asserted as against other governments or states. Their purpose is to encourage direct foreign investment, and they provide guarantees and protections about how each state will treat investors and investments from the other states to the agreement. If a company from one country thinks that the regulations from the country it has invested into breach the terms of the treaty, then that company can take the government to an international arbitration tribunal. The remedies in that type of case are damages, and these damages, the claims can sometimes be for billions of dollars. Many of the investment treaties are bilateral, so just between two countries. However, just to complicate matters, many modern free trade agreements also include investment chapters. So agreements that many people may have heard of, such as NAFTA, the North American Free Trade Agreement, or TPP, the Trans-Pacific Partnership Agreement, or TTIP, the Transatlantic Trade and Investment Partnership. These are complex modern trade agreements that include investment chapters, and those investment chapters are very similar to the old bilateral investment treaties. So you have two different types of agreement combined into one document. Now, there is no shortage of investment treaties that can potentially be used by the tobacco industry. There are some over 3,000 investment treaties worldwide. You have some countries such as Ireland and Brazil that have no investment treaties that they're signed up to, but almost all other countries are. And you have some countries such as the UK that have over 100 bilateral investment treaties. This has been termed the spaghetti bowl of treaties. Now, all over the globe, there is some growing concern now about these huge regional trade and investment deals and whether they, in fact, benefit citizens or rather corporations. And the tobacco corporations have for decades been alleging that tobacco control measures breach both trade and investment agreements. They have threatened governments around the world with litigation or with World Trade Organization disputes. And these threats and allegations continue today. The typical arguments that are made and that the tobacco industry seeks to use through submissions to government or letters to government are that their tobacco control measures will breach the World Trade Organization agreements, they breach international intellectual property obligations, expropriate property rights, or that they're arbitrary, or that they breach their freedom of expression. So let's have a think about, these are the disputes that I'm going to talk about now. There are two World Trade Organization disputes, one against Australia, which we are still expecting a decision back on, one on the US about clove cigarettes, which is a little bit of an old one, but I'll touch on that because it covers a lot of the issues. There's a challenge to the European Union Tobacco Products Directive, where there was a result from the Central European Court last year. I may touch on that if I have time, but otherwise there are two investment arbitration claims, both brought by Philip Morris, one against Australia and one against Uruguay. So let's have a look. Let's start with the World Trade Organization disputes. Before I get onto the disputes themselves, let's just mention the particular agreements for which are relevant. Now, there are quite a lot of World Trade Organization agreements, but for our purposes, there's the General Agreement on Tariffs and Trade, which governs the way in which goods are traded. The Technical Barriers to Trade Agreement, the TBT Agreement, which governs the way in which technical regulations, where product regulations are applied, that these have to be done in a fair and non-discriminatory way. The TRIPS Agreement, which is the trade-related aspects of intellectual property. Now, this obliges member states to set minimum standards, minimum protections for intellectual property within their countries. And then we have the dispute resolution understanding that sorts out the way in which disputes between countries are resolved. Now, these agreements are very lengthy, but again, for our purposes, the key principles can be sort of distilled into sort of core ideas. Now, that is that any regulation, and in this case we talk about product regulation, that is or could be restricted in some way in the way that trade is done, must be non-discriminatory, so it must be origin neutral, and it shouldn't disproportionately impact on products from one country instead of another. The regulation must have a legitimate objective. Public health objective is a legitimate one. But it must be no more restrictive than is necessary to achieve that objective. It must also adhere or comply with or be compatible with the minimum standards for intellectual property that are set. So the first case, it says, is a little bit old. I think a lot of people will have heard of it, in its US clove. And this concerned the law in the US which banned flavored tobacco. And now this ban included a ban on clove flavoring, but specifically exempted menthol. Indonesia decided to bring a challenge to this because of that exemption for menthol. And on the face of it, this was an origin-neutral piece of regulation. It applied to clove cigarettes wherever they came from, and exemption was for menthol cigarettes wherever they came from. But the facts of the case were, and continue to be, that all the domestically consumed menthol cigarettes were produced in the USA, and all the clove cigarettes consumed in the USA were imported from Indonesia. So the tribunal said that the obvious conclusion was that imported clove cigarettes are banned while domestic menthol cigarettes are allowed to remain in the market. And it found that these two cigarettes were essentially the same. They were like products, could be substituted. It also found that the public health objective, the public health reasons for banning flavoured tobacco were essentially exactly the same for clove as they were for menthol. Now, this case serves to remind governments to be careful when imposing different restrictions on different tobacco products, where those products could be found to be similar, or where the reasons for applying that regulation are essentially the same for each product. Now, this is an issue that may come up in recent times, because countries such as France and the UK have only applied plain packaging to cigarettes and hand-rolling tobacco, but not to other tobacco products such as cigars or pipe tobacco. So there are some risks of a challenge based on discrimination. And certainly the risk of a discrimination claim is reduced if the rules are applied to all tobacco products. Now, the WTO dispute against Australia's plain packaging. These were complaints made by Ukraine, Honduras, Cuba, Dominican Republic, and Indonesia in 2013. It's widely reported and pretty much well accepted that the Ukraine, Honduras, and Dominican Republic were being given both legal and financial support by British American Tobacco and Philip Morris. And there's nothing in the World Trade Organization rules that prevents industry supporting and funding a state dispute. Indeed, in many ways, you know, these trade disputes, that trade is done by private companies, and therefore if the private companies have an issue, they will go to their country to bring the dispute on their behalf. But of course, we're now dealing with multinational corporations that are bigger themselves than many of the states that they operate in. And I think that many of us feel that the tobacco companies supporting this, or essentially instigating these disputes, we feel it's somehow that it's a worse situation, or a situation that shouldn't arise. Now, the tobacco trade between any of these countries, all of these countries, and Australia is tiny or non-existent. So there's no tobacco trade between Honduras and Australia, between the Dominican Republic and Australia, or between Ukraine and Australia. Between Cuba and Indonesia, the trade is tiny. It's less than a few $1 million. So any remedy that might be imposed would be unnoticeable. Ukraine actually realised this and withdrew its dispute. I think the dispute was brought by one part of government without the other part of government knowing about it, and then I think when it joined up and they realised, they recognised there was no trade and that the dispute was damaging their reputation. Now, we should not underestimate the huge significance of this particular case. We expect the result to be in May this year. But the dispute is bigger than plain packaging, bigger than tobacco control. It concerns fundamental balance between trade obligations to other countries, on the one hand, and the space allowed under the WTO agreements for member states to regulate for the public good. Issues such as the legal test to be used by the dispute panel, the weight to be given to evidence, the deference given to governments to determine their own public health goals, all these things are at issue. There have been more third-party member submissions into this case than any previous WTO dispute. 34 countries, plus the EU representing a further 28 countries, have put in submissions. Now, I attended the hearing where these oral submissions were given when I was working for the UK government. It was clear to me that both in terms of the number of countries that supported Australia and the cogency of the arguments that were being used, that I would be very surprised if a WTO panel ruled that plain packaging breached any of the agreements. But the world is definitely watching this panel decision. Just to quickly look at a couple of the issues that are being concerned, that the panel has been concerned at, or the key issues really that the panel is concerned about. One is under the technical barriers to trade, Article 2.2, and the question for the panel there is plain packaging more trade restrictive than is necessary to fulfill its legitimate objective? Under the intellectual property agreement, the question is plain packaging a justified encumbrance on the use of trademarks? And then a further question is that the countries argue that the intellectual property agreement somehow implies a right to use a registered trademark. So when a company or a person has registered their trademark, they have a right to use it. The converse argument to that is actually that a person doesn't have a right to use it, but they only have a right to stop other people from using it, what's known as a negative right. Now, Australia has thrown everything at this dispute. It's cost them an awful lot of money. They've put years and years of effort into it. So again, we're going to wait for that result. One further thing that's just worth noting about this is that if a regulation is in furtherance or is to implement what is known as an international standard, then it kind of crosses the legal line under many of the WTO agreements. And Australia has strongly argued that the implementing guidelines to the Framework Convention on Tobacco Control are international standards. And therefore, the recommendations for plain packaging that are in the guidelines for Article 11 and 13 are also an international standard. And this is another fundamental question that this dispute is going to deal with, is the relationship between these two international agreements. And it's going to be a key test for the legitimacy of the Framework Convention as an international technical standard body. I'm looking at the time. I'm going to skip this on the EU Tobacco Products Directive just because I want to get on to some of the other cases. But if we have time in the Q&A, maybe I can touch on it then. So now I want to look at investor-state dispute settlement. So we're moving on from trade, we're getting on to the investment disputes that happen under the bilateral investment treaties. Again, before I get on to the cases, let's look at the key protections that are given to foreign investors under investment treaties. The first one, and really the key one for many of these cases, is that these treaties promise not to expropriate the property of the investors from the other country. And what this means is that governments will not take the property of foreign investors without a lawful process and fair compensation. Now, this sort of provision was initially designed to prevent nationalization of industries without giving compensation. But it also has been interpreted to include indirect expropriation, which is where a regulation prevents an investor using its property or substantially impairs the value of that property. And property, we should note, includes intellectual property, which includes trademarks. Another clause that is often argued is the fair and equitable treatment clause, which covers a multitude of sins, if you like, but it means that regulations that affect an investment should not be taken arbitrarily, that there should be a stable regulatory environment, and that governments will respect due process in the way the laws are adopted, and that regulations will have a rational basis. Investors have a legitimate expectation that a government will adhere to all its both domestic and international agreements, and investors must have access to a fair domestic judicial system. So if an investor thinks that, if a foreign investor thinks that the government of the country it's investing into has breached the terms of one of these agreements, it can take a dispute to an arbitration panel. These arbitration panels are constituted under a number of different systems, one of which, the most popular, is set with the World Bank. But these are ad hoc tribunals, they're not sitting courts. They're constituted with 3 arbitrators which are selected by the parties, and these are often international lawyers that will often be representing parties in a different case. And so there's a very limited conflict of interest rules. There's limited transparency of process within these arbitration panels. There's real concerns of pro-investor bias. There's no appeal process, which leads to many inconsistent rulings. There is a potential for billions of dollars being awarded in damages, and the cases take years and years and cost millions of dollars in legal fees. There haven't been many public health measures that have been the subject of these claims, but there have been some, and some have been successful. A far more common disputed public interest issue is environmental regulation. There have been only 2 claims against tobacco control measures. These have been made in recent years, despite the fact that the tobacco companies have been threatening these types of claims for many decades. But these 2 claims have had a real regulatory chilling effect on governments, and we shouldn't underestimate that impact. So the first case, the Philip Morris Asia and Australia, which is Philip Morris challenging Australia's plain packaging. The 2 main arguments that Philip Morris made in this claim was that plain packaging had the equivalent effects of expropriating the property rights in its trademarks, the ones that could no longer be used on the packaging, and that the measure wasn't arbitrary and unreasonable on the basis that it claims there was no evidence it would work to reduce smoking rates. Of course, what its arguments amount to is that its customers have a right to die with the colourful packaging in their hand. So I just want to remind you, there is a spaghetti bowl of bilateral investment treaties that exist around the world. And I now want to look at the way in which Philip Morris tried to use the spaghetti bowl to enable it to bring the claim. So the starting point is that between Australia and Hong Kong, there was and is a bilateral investment treaty. But as between Australia and Switzerland, there is no bilateral investment treaty. Philip Morris's main parent company is located in Switzerland. And now this parent company owned 100% of the shares for Philip Morris Australia. So Philip Morris International was a foreign investor in Australia, but it was one that had no particular investment rights. In April 2010, Australian government announces its intention to proceed with plain packaging. In February 2011, some 10 months later, Philip Morris restructures itself so that it moved ownership of its shares in Philip Morris Asia over to Philip Morris Asia, which is located in Hong Kong. It then, in December 2011, brings a claim as a foreign investor based in Hong Kong against the Australian government by using the Australian-Hong Kong Bilateral Investment Treaty. Now, the Arbitration Tribunal found that this was done for the sole purpose of bringing a claim under this investment treaty, and that therefore the claim was an abuse of its rights. The tribunal therefore declined jurisdiction and the merits of the claim were never considered, despite the fact that all the arguments and the evidence had already been submitted to the tribunal. Now, this was a good result, but this was a legal challenge that should never have been brought. It's confirmation that the industry is prepared not just to use, but also to abuse this legal system. Australia spent 4 years and tens of millions of dollars defending the claim. And we know for a fact, because the Prime Minister said so specifically, that in New Zealand, they delayed their plain packaging legislation for over 2 years, pending the result of this case against Australia. The claim also enabled tobacco companies to keep threatening other countries that considered plain packaging. Now, the other case that resolved last year, Philip Morris against Uruguay. This was a genuine David and Goliath case. The Philip Morris his global annual revenues dwarf Uruguay's GDP. And I think it's also worth looking to say that Philip Morris is not a major player in Uruguay. Even on its own estimation of its claim, it was only claiming $25 million. The total legal fees and costs of all the parties were therefore more than the damages that were being claimed. This claim was not about Philip Morris's investment in Uruguay. What it was about was it trying to stop and prevent legitimate tobacco control measure, not just in Uruguay, but globally. The two measures that were being challenged were the single presentation requirement, which was a regulation that prevented multiple variants. The purpose behind it was to prevent the health reassurance brands. So Marlboro Gold was the same branding as Marlboro Lights, and Marlboro Blue has the same branding as Marlboro Miles. And the Framework Convention on Tobacco Control recommends that countries prevent this type of misleading branding, and this was Uruguay's way of trying to do it. So if you had a brand, you could only have one variety of that brand. Then we also had 80% pictorial health warnings, which were challenged as well. The key claims were, again, the same as in the Australia case, that these measures expropriated the trademark, the property in the trademarks, and that the measures breached the fair and equitable treatment obligation because they were arbitrary, the measures were not supported by evidence, and there was no due process in the way that they were adopted. But the ruling that came out in July last year was extremely strong. The tribunal relied heavily on the Framework Convention on Tobacco Control as an instrument that setted international norms. So, for instance, it said that adhesion to the FCTC represented an important, if not indispensable, means of acquiring the scientific knowledge and market experience needed for the proper implementation of its obligations. And in these circumstances, there was no requirement for Uruguay to perform additional studies or to gather further evidence in support of the challenge measures. The tribunal also said that there should be great deference given to governmental judgments of national needs in matters such as the protection of public health. So the tribunal was sort of reaffirming and restating that governments have a very strong right to regulate for public health, and that this shouldn't be second-guessed in some way by investment tribunals. Now, also one of the things that Philip Morris tried to argue was that they had some sort of legitimate expectation of a stable regulatory environment. And the tribunal came back and said that, look, manufacturers and distributors of harmful products, such as cigarettes, can have no expectation that new and more onerous regulations will not be imposed. And then finally, the tribunal also was asked to look at issues that although this is an investment law case rather than a trade case, similar issues are being argued before the World Trade Organization case against plain packaging that we're going to learn about later this year. So they argued that they had a right to use their trademarks, and they argued that the regulations breached the World Trade Organization rules. And the tribunal said that no, there is no right to use, there's only a right to exclude others. And they also said that the FCTC, the Framework Convention on Tobacco Control, and domestic tobacco control laws don't breach these international intellectual property treaties, such as TRIPS. And the FCTC and TRIPS should be read in a compatible way. So we already have an international body, an international tribunal making these proclamations. So it's going to be quite surprising, I think, if we get the WTO saying something very different later this year. There was some dissenting arbitrator. Now, it's well recognized in arbitration cases, investment arbitration cases, particularly those that concern the balance between investor rights on the one hand and the space for governments to regulate on the other, that the choice of arbitrator is perhaps the most critical aspect of the litigation process. Each party appoints one arbitrator, and generally they agree to a third, or a third one is appointed by the centre. Now, the arbitrator appointed by Philip Morris was Gary Bourne. Now, he's a very well-respected international lawyer of some repute, but the fact that he was the one that gave dissenting opinion and would have awarded damages to Philip Morris demonstrates how the choice of arbitrators can have a real impact on the outcome of a case. Let's just have a quick look at what he said. Firstly, he said that there was a denial of justice. Now, I'm not going to go into that, but essentially what he was saying is that there was a national claim that Philip Morris brought in the Uruguayan courts, and Gary Bourne said that hadn't been dealt with properly. But more importantly, he also said that the single presentation requirement, in his view, was not required or contemplated by the FCTC on the one hand, and that he said no meaningful internal discussion or consideration of the SPR had occurred within the Ministry of Public Health. Now, Uruguay disputed this, but it has to be said there was almost no documentation of what that consideration or due process had been within Uruguay. And this is, I think, a good reminder to the governments that due process needs to be taken, full consideration of public health measures needs to be had before they're implemented, but also there needs to be a good record of what is done within government. So finally, before we go into Q&A, it's just to say that despite very strong rulings from the Uruguay case, and despite other rulings as well, the tobacco companies continue to allege breaches of WTO and investment agreements. And on this slide, I've seen just a couple of issues that I've been dealing with recently. So, for instance, there's litigation in Pakistan at the moment where an NGO is trying to get a court ruling to force the government to implement the law requiring 85% graphic health warnings. The tobacco companies have come forward as interveners in that case, and they are, a lot of their claim is alleging that there are breaches of the WTO agreements and international intellectual property obligations. In Slovenia, where they're trying to implement plain packaging, there continues to be debate, and media articles and a number of experts in Slovenia are bringing out these same arguments around WTO agreements and intellectual property laws. So it carries on even today. So I'm happy now to go to Q&A and to see if anybody has any questions.
Thank you very much, Rob. That was a fascinating overview of the current state of international tobacco litigation. We've had a few questions come in during your very informative presentation. So I'll start with this one. You mentioned that for the most part, trade and investment agreements give no special treatment to tobacco, but there are one or two exceptions to that. What are those exceptions?
So that's right. So, I mentioned that tobacco really hasn't been, and tobacco control measures haven't been given any special treatment, despite the sort of internationally recognised position. That said, there are general provisions in a number of particularly more modern agreements that say that there might be exemptions or exceptions that can be justified around public health. However, the year before last, when the Trans-Pacific Partnership Agreement, which is the big trade agreement around the Pacific Rim of 12 countries, and in that agreement, there was a clause in Chapter 29 that said that companies who try to bring a claim against a tobacco control measure could be denied the benefit of the investor-state dispute system. In other words, if one of these countries so elected, they could stop any claim against a tobacco control measure being made. Now, TPP has, for the moment, ground to a halt. Although the text has been finalised, it looks at the moment like the agreement isn't going to come into force because Donald Trump has made very many sort of negative comments about the agreement, and the agreement really needs America to ratify it in order for it to come into force. But we will see how that goes. But it was a really sort of historic clause to be included, the way that it exempted a particular type of product regulation. And that's now been followed in at least one other example. So the free trade agreement which again includes an investment chapter, that's between Singapore and Australia, has now included a very similar clause to that, excluding any claims being made against any tobacco control measure. And we're hoping that this produces some sort of momentum to other states to include that type of measure, or to give sort of greater consideration to the other ways that these treaties can be drafted to prevent similar claims like this happening in the future. I think part of that is not just to ensure that if a claim is brought, it can be won, but to prevent the claims at all. And the reason for that is that the tobacco industry has shown itself it's prepared to bring abusive claims, for which there is no merit, or for which it has tried to shop around for a treaty. And it does it not because somehow it thinks it's due damages, or because it might even win, but because they have such a chilling effect on other governments in bringing these types of regulations. So, you know, the fact that it can delay other countries by 2, 3 or years in their regulations, that's a win for them, even if they ultimately lose the case.
Okay, thank you. And here's another question. Are the trade and dispute decisions generally available online or accessible to the public?
So the answer to that is yes and no. So WTO decisions, WTO cases are confidential in the way that the proceedings are run, but the results are always available. So the decisions of all the World Trade Organization cases are available, and also the sort of interim rulings or procedural rulings. So if you go onto the World Trade Organization website, you can find all the rulings. Countries, after the cases are concluded, some countries will publish their materials that they put into the case as well, but that's up to the country themselves. So that's World Trade Organization disputes. With investment disputes, it's all down to the parties to the arbitration disputes. Transparency has been a real bugbear. It's a real sort of systemic concern. Most results are available, and if you go onto the ITA website, you can find most of the results of them, but not all of them. There's much more of a move for all the case documents to be made available as well. In the case of Uruguay, the Uruguay case, we think that the Uruguayan government, or we're fairly certain that the Uruguayan government is going to release all the documents in the case, so all the pleadings, all the evidence, at some point later this year. Certainly the actual decision is available and can be easily found online. Also, if you go to the the Tobacco Free Kids website and have a look around the international site, you'll find a very, well, I think it's a useful summary of the ruling as well. So instead of 100 pages, you can have a look through 5 pages of the ruling.
Okay, thank you. Here's one other question. Given the very strong judgment from the Philip Morris v. Uruguay tribunal, can we expect the tobacco industry will no longer use investment treaties to challenge tobacco control laws?
Sure. Well, I think there is, to an extent, I would say that the importance of the success in the Uruguay case has to be measured against what would have happened if Uruguay had lost. Because if Uruguay had lost, it would have had a huge, huge impact on states implementing these strong packaging laws. Because, and I think also it would have led to potentially a plethora of claims being made in these international tribunals by Philip Morris and the other tobacco companies. Now that we've had a fairly strong judgment that sort of pushed Philip Morris back, I think that the companies will regroup and think about the way forward in this particular regime. They may decide to focus more on domestic challenges. But we can't exclude further cases because we know they bring cases even where the merits aren't good. We know they bring cases that sort of repeat and repeat the legal arguments that have been knocked back in other places. There is no system of precedent within the international arbitration, investment arbitration regime. So the fact that one ruling really only applies to one specific situation. I think the biggest deterrent for the tobacco companies in bringing more of these claims is that there was such a huge reaction to the claims that Philip Morris made against Australia and Uruguay. And these cases almost became a cause célèbre for the opposition to things like TPP and TTIP, these big agreements. And so I think what will happen is a lot of the rest of the business community found that they didn't really want the tobacco industry coming along and using this system. because it's shone a spotlight on the broader failures of the system itself and the broader problems of the system itself. A system which business generally quite likes because it's generally a pro-investor system. So I think the appropriation of the rest of business world is likely to be more of a deterrent on Philip Morris than anything else. But I think if we get 2 or 3 years down the line and things have gone a bit quiet, I think we can't rely on this one case to say that further cases won't be brought.
Okay, thank you. And here's another question that just came in. Are there any pending international legal disputes involving e-cigarettes or ends?
No, there aren't, but I think that it may be likely. So there was one case which was regional rather than international, and so within the European Tobacco Products Directive, Article 20 of the directive regulates e-cigarettes for the whole of the European Union, and it sets things like standards on the size of the containers, the strength of the nicotine, the way in which they can or can't be advertised, or rather can't be advertised, and small health warnings on the packaging as well. And one of the e-cigarette companies from the UK challenged the directive up to the Central European Courts, the Court of Justice of the EU. So, and it challenged the validity of that directive. The court knocked that back and dismissed the claim. So that's been the sort of one of the big international-ish claims against e-cigarettes, but that has been resolved as of last May. But I would say that with more and more countries regulating e-cigarettes, and in some cases regulating e-cigarettes more stringently than they do tobacco. So some countries have banned e-cigarettes where tobacco is lawful. And I think there's the potential out there for a claim, and we know that the e-cigarette industry is now largely controlled by the tobacco industry. I think it's not unreasonable to expect a big international claim being made at some stage, particularly in those countries that are regulating it more severely and more harshly than tobacco itself.
Okay. Thank you, Rob. I don't see any other questions coming in. We can wait for another minute or so and see if anyone has anything else, and then I think we'll wrap things up.
Okay.
Okay. All right. Well, I think we're gonna conclude now. Thank you, Rob Eckford, for an absolutely fascinating presentation, and thanks for all of you for attending our webinar today.
Thank you very much.